What's up? My name is Stephen Williams. I'm the founder and president of the creditrepairshop.com. In today's video, I want to talk about something that's specifically on the rise right now, and that is lawsuits from debt collectors. They are going crazy. My office has been getting a ton of documents from customers that are getting sued. People are reaching out to me from my YouTube channel. People are just going over, reaching out to me from the internet. They're saying, I need help. They are trying to sue me for 5, 10. One of them that I had right here was for over $25,000 from a debt collector who has claimed to have been assigned a debt, or debt collectors that are just outright saying that they purchased a debt. And something that really concerns me a lot, like with that I've never thought about this ever happening, is that when debt collectors buy debt, they still used to always have to get someone in the area to file the case. Well, due to COVID, what's happening right now is that they could get a paralegal to file the case in your area, but they can do the hearing virtually. So it takes down their cost. And what has happened from that is they are taking even more risk. They're taking even more risk because they know that the vast majority of consumers who receive complaints for court summons to go to court, probably 95% never show up. And of the 5% that do show up, probably only 1/10 of 1% actually know what to do, how to respond to the court summons or citation complaint the proper way. Well, I want to talk to you about something that you can do. And we also have a service if you want us to do it for you. But let me tell you, uh, probably the fastest and the easiest way to put the debt collector back on their feet is to do a debt validation. But you have to do that validation off of the summons complaint. You can't just say, I don't owe this debt. You have to structure your response the way that the court has in your area wants you to submit it. I've seen hundreds of different summons from different areas, different states, and it seems that most of them are doing them all, have some type of variation in them. One of the things that I see from a lot of debt collectors is that they're not even really doing a full summons complaint. They're just putting the bare bones minimum on there because they know most people don't know what to do or they won't show up. So let's go over something that you could do right away. And if you do this the right way, you could put debt collectors back on their feet. The first thing that you should do is you should look at your summons and you should answer every question on there. Now, we're not saying that you are admitting to anything. You should just state that there's not enough information for you to admit or deny the information that they're stating in their interrogation against you. Uh, so you're not just saying, hey, this isn't me, all this stuff that you see on YouTube. You're basically stating that you need more information and you have a right to get all that information. Uh, some of the times they will include, or most of the time they'll include the last statement. So it'll basically go like this. This is, they'll say your name and you lived at this address. You wouldn't deny that. That's your address. They may say that you were served at an address. If you were served at that address, yes. If you were not served at that address, state no. And if you've never lived at that address, you state no. Uh, then they may say you owe this amount of money. And right there is where you would say that you don't have enough information to either admit or deny. And you have a right to do that. And they may even state that you owe them the money, but you never did business with them. So you're asking for clarification with the relationship between you and the debt collector. The next thing is that you have a right, and a lot of people just never thought about this, and the more I read about uh, uh, the debt collector's process for submitting evidence and what evidence is approved by the court, is that you have a right to have them strike the evidence that they've submitted. Usually, and if you have a summons sitting in front of you, they've usually only made statements, which is what they've put in writing, and then they submitted the last invoice or the last bill that you had from the original creditor. Well, that's not enough information. And I would bet you, if you were to look at that statement that they sent you, that they've blackened out the entire account number except for the last four. That gives your door open to let the court know that you don't have enough information. You need to know the complete account number. When you ask for that information, what happens on the other side is that they have to go to the original creditor to get that information. Some of the times, from what I've seen, is that they're not able to get that entire information. Some of the time, they are able to get that information, but the door still has not closed for you to win the case. The next step in your strike um, to not allow them to have that evidence is that they were never in the room or employed or had any type of way to verify the documents that was passed along from the original creditor are actually true. Basically, the only way that this is something that no one ever asked them. Like, were you in the room because you're the one that's presenting this in court? Where did you get your information? Was it just hearsay? And that goes into the next point, is that they cannot just come to court on hearsay if you bring that up, that you want them to strike the evidence that they're presenting, which is just a bill and their statement saying that you owe this amount, and their statement saying that they've been assigned or they purchased it from another, from the original creditor, or they've been assigned from a debt collector to collect it. That's not enough information. You have a right to see what was the processes of everything that they're claiming about this debt, and you want them to submit that to the court. And here's where the problem comes in, is that the individual, the debt collector or the attorney that is submitting the information, raising their hand, swearing to the judge, was not in the room when they got that information from the original creditor. They was not in the room when they decided to batch up all of those accounts and sell them. They don't know if it's true or not. All they did is purchased it. So this is probably one of the best avenues to get a case either dismissed or delayed. Because I'm not saying that an original creditor will never give all the information. I'm not saying that a judge that you get in front of won't be the type of judge that's just not a consumer uh, type judge where they just do everything for big business. But this is an option that you should use. And I've talked about it in my other videos about when you respond to court summons, because if you don't respond, you're going to lose just by default. And if you don't show up, you're going to lose by default. If you show up and you have nothing with answers when they ask you, you're going to get a judgment put on you. So you at least should have the information so you're able to fight, to have to put up your best defense. Even if you lose, at least you had a chance to put up your best defense. And you never know, any debt collector that does not want to, lose their license by submitting false evidence, or trying to present a case without true evidence, they don't want to lose their license, or they don't want to get penalized by the court. So they would usually, what they would do is they would just back off and say, either we're not going to go after this one. They may submit to have it dismissed, or they just may ask for more time to gather the information. But there's going to be problems that will arise. They don't want to go through all of this trouble. So There's a service that we offer. Uh, this has been something that's only been internal to our customers, but now we're going to also make this available to uh, people that are not customers. It's an extremely low cost to have this prepared, but it gives you a defense, and we will get all of the information that you need, preparing your answers to the complaint, preparing the motion to strike the evidence, and then if you have to have a certificate of service, some locations want you to file that, some just allow you to submit your information and they write that up for you. We'll put all three of those together for you to present to the attorney, that is for the plaintiff, to the clerk of courts, so you can get that to the judge, and then you have your day in court, and at least you have something to go off of. The link is below this video if you'd like to have that service done for you. If not, you can read up on how to do it. With your court summons, it has all of the instructions, and you can submit your defense that way also. So this is Stephen Williams, founder and president of the creditrepairshop.com. Thank you, and until next time.